My name is Anne Thomas. I'm a solicitor and partner with the International Family Law Group in London. I've been a family lawyer now for a good number of years, and what I've noticed recently is the huge influx of cases where parents want to relocate to another country with their child, and there's been a situation where the other parent has said, basically, I don't give my consent, so you can't go. In that impasse situation, if there is going to be no resolution, and invariably there isn't a resolution, then the only option is to take the matter to court. So let's first of all look at what relocation is. In a happy marriage or a happy relationship, if one parent wants to relocate to another country with the child and the other parent agrees, there's no issue. Both the child and the mother or the father go to the other country, or the other parent goes too, on the basis that it could be for a fixed term, or whatever the situation is. So in a happy relationship, there's no issue at all. But if there's a separation, or what invariably happens is after a marriage is broken down, one parent then wants to either go home or to relocate to another country for reasons of employment, or just to be with family in a situation when there's nobody to give that support in this jurisdiction any further, then that is a case that is very, very different from physical consent, because consent then has to be given either through mediation at the end of a mediation period, which invariably that doesn't work because the two parties are so polarised in this situation, where one person says, yes, I really want the children to stay here, and the other person says, yes, I really want to move to the other country. So mediation doesn't usually work, but if it does, then great. Or to go to a court where you'd have to issue an application for the judge to determine what is going to happen to the child in that situation. These cases are cases that no judge ever wants to find. The reason for that is it's so difficult in a family situation where both parents are equally as loving towards their children, can equally provide a fantastic home for the children, and basically they have a good relationship with them, holidays, alternate weekend contact, whatever the contact arrangement's going to be, and the children want to be with their father. In some situations, the decision the court has to look at is very, very simple, because you might have a situation where one parent is clearly the primary carer, where the other parent doesn't have very much of an interest or plays very big a part in the children's lives. In those cases, if a father would say, I don't give my consent in a situation where he hasn't been very active in the children's lives, then it's more or less certain, but not absolutely certain, that that mother, if she's put up a good case for wanting to relocate, will be permitted to relocate to the country where she wants to go. But this can't be an application in that situation where a mother says, I fancy going to France or Spain. It's got to be a well thought out decision with good reasons of how she's going to be supportive over there, how she's going to be supported herself, what she's going to do so far as work is concerned, where the children are going to live, where they're going to be educated, etc. So in those situations where you've got a clear primary carer with one parent with very little input, that decision for the court with a well thought out application by the mother is relatively simple. The difficult ones, as I've said, that judges just don't like getting involved in, obviously they have to, is the case where you've got very equal parenting skills that both parents show to their children, albeit that they live in separate households. In that situation, a judge has to look at what is the best interest of the child, and what happened for a number of years before 2011 was that the courts based their decisions on the case of Pain and Pain, a case we've been stuck with for a good number of years, which basically gave a passport to the mother, who was a primary carer, to relocate, provided she could prove to the court that she wasn't motivated by a desire to cut the father out of the children's lives, and also she was convinced that what she was doing was for the best. And if the mother said, look, if I can't relocate to this other country where I'm going to be a much happier person than I am here, in many situations the judge would allow that relocation to take place, but taking into massive extent the children's relationship with the father and how much of the contact period they would have with their father following that relocation. But what happened in 2011 is the case of CKMK that we as lawyers call re-K. When the judge looked at pain, and the Court of Appeal looked at pain very clearly, and said that what's been happening in the case of pain was the guidelines that Lord Justice Thorpe emphasised in pain had somehow over the years turned themselves into legal principles. And what was being said in pain was guidelines the court should consider, not basically a judge to tick boxes and say, well, this has happened, that's happened, we can satisfy it's going to work really well, therefore this mother can go. What happened in re-KCK is that it brought it back to the welfare of the child and what is in the best interests of the child, and the welfare principles that are always used in the contact situations or residence situations, anything under the Children Act where the child's interest is paramount. The judge would always look at the welfare principle, but not in as clear way that it now has to, following the case of re-K. What a judge now has to look at, and I'll just go through each of those principles and I'll read them to you. The first one is that the court shall have regard in particular to the ascertainable wishes and feelings of the child concerned, considered in the light of his age and understanding. So the judge is going to look at and take into account the wishes and feelings of the children, what they really want to do, and what is therefore the best for them given their age, and what's their understanding of what's going to happen as well. What a judge has to look at is a child saying, I want to relocate because I've got a holiday concept of where I'm going to be going. This is a permanent move, and if the child is older, more weight must be placed on that child's wishes and feelings. So how do we ascertain the wishes and feelings? It's rare in this country for a judge to speak to a child to ascertain what their wishes and feelings are. So we have a CAFCAS officer, reporting officer, to assist the judge, who will speak to the child, see the child with both parents separately, and then report back as to what he or she thinks is going to be best for that child to either relocate or to stay in this jurisdiction. The next one is the physical, emotional and educational needs, again, of the child, and looking at his physical needs when he moves into another jurisdiction. Perhaps there could be reasons where a medical problem that can't be looked after or maintained in the other country. Looking at educational needs, will that child be able to slot into the educational system in the other country, or will there be a problem with that? All that has to be taken into account, so looking at those physical, emotional and educational needs. The emotional needs obviously being if there's a very, very strong bond between a child and a left-behind parent or a proposed left-behind parent. Looking at the likely effect of him of a change in his circumstances. So let's look at what effect the change where a child is being uprooted from all he or she knows into another country, albeit with the parent. What effect is that going to have on that child of leaving everything that he or she knows here? His age, sex, background and any characteristics of his which the court considers relevant. So again, looking at all those relevant factors. And it may be that if you had a group of children, the older ones are really keen to go and the little one maybe it can't give his views or her views because of the age. A judge has to look at that and consider what is therefore best for that family, because what a judge is very reluctant to do and basically in my experience tends not to do is to split siblings, to say that one or two children go with one parent and one is left behind. So it has to look at all the circumstances of that relocation on the family. Any harm which he has suffered or is at risk of suffering, and this is with a child moving to another jurisdiction or a child having to stay here and put up with any violent situation or dreadful situation that's been happening here. So a judge has to balance all that as well with the decision. And the last one, how capable each of his parents and any other person in relation to whom the court considers the question to be relevant is of meeting his needs. So looking at the child's needs. What does that particular child need? It's not a general test, subjective test, looking at that particular child and that particular child's needs. And the last one, the range of powers available to the court under this Act in the proceedings in question. So what can a judge do? What powers does the judge have in those situations? So when we've got that before the court, And you'll find that most judgments now, if it goes that far, a judge will have to put in his judgment a referral to each of those, the welfare checklist, to make sure that it's been carefully considered in respect to that child. So we have the court situation. We've got a CAFCAS officer giving some assistance to the court as to what should be happening. The judge doesn't have to follow what the CAFCAS officer is saying, but in his or her judgment will say, I didn't agree with what the CAFCAS officer said for these reasons. So as long as those reasons are carefully thought through, then that will be sufficient to stop any appeal being made. So the judge always has control and always has the last decision. I've known some cases where a CAFCAS officer is supporting or not supporting a relocation, and the judge says, well, I've heard this, I've formed my own view, and has basically overturned what's been said. So we've got the application through. We've got a situation when we've got to give some information for the judge as to what the judge is going to look at to consider with the relocation. And this will be statements filed by the mother, filed by their father, and then obviously the CAFCAS officer will fit into that and will meet both parents and then produce her report for the judge to look at. We would also put in expert evidence, usually, not always, but usually. Expert evidence of what is going to be happening in the other jurisdiction, so far as education is concerned, schooling, medical care, all the things you'd have to look at to make sure that child is well looked after or going to be well looked after in the other countries. So maybe a letter from a solicitor who's an expert in law in that jurisdiction. The most important thing that you have to look at is, because this is what the left behind parent and the judge is going to be concerned about, when that parent leaves the country to go into the other jurisdiction, what are you going to do to make sure that that left behind parent has the contact that was agreed or ordered by the court? So we want to look at a way of enforcing that order in the other country. And the 1996 Hague Convention has given us a huge benefit as family lawyers, because the signatories to that particular 1996 Hague Convention basically will uphold the contact that's stipulated in a court order in those signatory countries. In other countries, we have to look at a mirror order, which is basically an order in the other jurisdiction mirroring precisely what's been said in the court here. And that will negate any situation in the future where there is a problem with contact not taking place. What I would always say as a lawyer is not to let the children go until you've got the order mirrored in the other jurisdiction. Obviously, if it's a 1996 Hague signatory country, you don't need to worry that much, but you need to look at certainly countries that are not signatories to the 1996 Hague, not the Hague Convention on International Child Abduction, but the 1996 Hague Convention countries. I think one needs to be very careful of presuming that an order can be registered in other jurisdictions, because you need to look at that, because in some jurisdictions you cannot register an order, you cannot automatically enforce an order, so you need to do your research on that and present that to the judge before the hearing as part of the process that the judge has to consider, not afterwards, because there shouldn't be a big delay. There's already a long delay before this matter comes to court, so you need to look at that. I think what I've found in the cases that I've done is that where a child has got a very good relationship with a father who's going to be left behind, and I'm saying a father and a mother, presuming that the mother always wants to relocate and the father is left behind, although that isn't always the case, but what I'm saying today, that's the example I've given you. I've known cases where a left behind parent will be allowed to have maybe a whole month of contact during the summertime when it's the long school holidays at whichever country it seems to be. It's quite common throughout the world. Where there's regular telephone contact, all sorts of things that upholding a cultural belief or religious belief or something, all that can be put into a hugely complicated order, and then that will give the left behind parent a really good peace of mind. I think the courts say basically, because the child or the children are living with the parent who has relocated, I think it gives that other parent something to say, look, that he can or she can be an equal part in that child's life, and give them a long period of time with them for contact. So 4 weeks in the summer doesn't equate to having a child for a whole year during the sort of half-term holidays, long weekends and whatever, but I think that goes some way into a judge saying, look, it's a very difficult decision and I've had to give as equal contact as I possibly could. I think with the things that are changing now with Brexit, etc., it's free for us to move between European countries, and it's difficult to say what's going to happen in the future so far as many issues concerning child law is concerned, but it's never been the case in child relocation that you can move freely with a child between member states. So again, even if it's living in the border of Spain and France, you still have to get that consent before you move across. And if consent hasn't been obtained, you're looking at child abduction proceedings. It's a hugely serious thing to happen. And this is why I think, because there's been more publicity to this, that the relocation of children case has been much, I suppose, advertised, and much more people are aware of the fact you can't just shift from one country to another. You have to do that and get the proper consent for the child's sake. Obviously, the child has a right, absolutely equal right, to have parents, parental contact and to love their parent as much as possible. So you have to look at these cases, obviously, are always on their own facts, and one really hopes, although it's not going to be the best situation, that contact can be maintained as much as possible, and that parents, when they have the relocation, don't just shut down so far as the other parent's concerned and adhere to the order, because sadly the only way of making sure that that is going to be adhered to is, as I said, with the mirror order or the 1996 Hague, but again it's going to be costly proceedings as well to look at. So it isn't all absolutely fine when a child is relocated to the other jurisdiction, because then that other jurisdiction will take all to further decisions in respect to the child, and that's why you've got a good starting point with the mirror order or with the 1996 power of the 1996 Hague Convention, and that's a good starting point so that the father can say, look, this is what was agreed, and this is what the mother hasn't adhered to, and obviously to give the good reasons why. So that's a taster of what the child relocation is about so far as England's concerned, and as I say, it's a very, very difficult area and hugely costly as well. So if there is a way that we can try and make a cheaper way of resolving these disputes, it would be fantastic, really. But I think it's a very long haul, and as I said, the parents are very polarised. So that's all I have to say on child relocation, and if I can be of any further assistance, then please make contact with me and Thomas, the International Family Law Group in London. Thank you.